Here at Scott Legal, we know how to navigate the often complex and daunting immigration laws to help keep families facing removal proceedings stay together to live and work in the United States.
I received my green card through marriage to my U.S. citizen spouse. When I was applying for citizenship, I was denied and placed in deportation proceedings because the government is alleging that I should have never received my green card because of marriage fraud I committed from a prior marriage. Is there anything I can do to attempt to save my legal permanent resident status?
Possibly. Because you were placed in deportation proceedings, based on an allegation of misrepresentation, regardless of it being innocent or intentional, you may be able to qualify for a waiver before an immigration judge, to have the judge consider whether to forgive the misrepresentation at the time of applying for the green card. However, whether you qualify for the waiver will depend on whether you are currently legally married to your citizen spouse or whether you have a child or parent who are either legal permanent residents or U.S. citizens of the United States. This waiver is known as the 237A1H waiver based on Section 237A1H of the Immigration and Naturalization Act. This waiver serves to waive any violation that should have disqualified you from obtaining the green card relating to fraud or misrepresentation as indicated pursuant to Section 212A6C of the Immigration and Nationality Act or for lacking valid documents due to fraud or misrepresentation pursuant to Section 212A7A. Since it appears that you are being accused for misrepresenting that your marriage to your U.S. citizen spouse was valid at the time of applying for your green card, because your previous marriage was not properly terminated, it appears that you're being accused of committing a misrepresentation pursuant to Section 212A6C.
Although I still live with my spouse, I never proceeded to finalize the divorce of my previous marriage. However, I do have 2 U.S. citizen children. I also have a father who is a legal permanent resident. Will I be able to qualify, and is there anything else I need to demonstrate to be granted the waiver?
Yes, because of your children and parent, it appears you will qualify for the waiver. Specifically, you will need to demonstrate to the immigration judge that you are the spouse, parent, son or daughter of a U.S. citizen or legal permanent resident. Your children and parent are qualifying relatives for the waiver. You are in possession of an immigrant visa or equivalent document. Having been granted the green card essentially fulfills this requirement. You were otherwise admissible at the time of admission to the United States. If your only violation was the misrepresentation and you committed no other violation, you will meet the last factor to qualify for the waiver. Furthermore, this is considered a discretionary waiver where the judge will review the circumstances of your violation, and although the waiver doesn't specifically require it, a judge will be allowed to weigh any positive and negative factors in your life as well as consider any hardships to your family or yourself to determine whether to grant you the waiver.
If my request for the waiver is granted, can I still face any future consequences for the misrepresentation I committed?
No, the waiver cures or forgives the misrepresentation where the government can no longer proceed to deport you based on this past violation, meaning that you will be free to continue living and working in the United States without any further consequence.
I do have a past driving while intoxicated conviction and drug-related conviction from the past. Could these convictions affect my application for the waiver?
Possibly. These convictions may affect the discretionary aspect of the waiver where the judge could conclude that because of your perceived continued violation of U.S. laws, does not warrant granting you a second chance. In this situation, it is extremely important to convey to the judge that you are remorseful of your past history and demonstrate how you have rehabilitated from your past indiscretions as well as demonstrating all good factors in your life and potential hardships deportation could cause to you or your family. Remember, it's shifting the balance in the judge's mind to your favorable factors from the negative factors. Furthermore, with respect to the drug crime, this type of conviction could expose you to being deported for violating the immigration law that makes a legal permanent resident deportable based on a conviction for violating a drug-related offense. Please view our video discussing the different crimes that can affect legal permanent residents. Assuming your drug conviction does expose you to deportation as well, understand then that the 237A1H waiver will not be sufficient to defend against your deportation. You will still likely require the 237A1H waiver to forgive the misrepresentation, but you will also need to qualify for a second waiver, known as cancellation of removal, to be able to also waive the drug crime. We also have a video discussing the cancellation of removal waiver available for you to review. We have new immigration videos every week. If you are new to the channel, please hit the subscribe button and bell. You can also sign up for one of our webinars, or get a free immigration guide, by clicking the link below. Immigration laws make it where it's not always clear whether a non-US citizen is deportable or whether there are ways to defend against deportation, so that is why we are here to help. You can contact us by calling 212-223-2964 or by sending us an email. We look forward to hearing from you. You can also schedule your consultation by clicking on the link below, where you can choose a day and time that is most convenient for you.